You may be dealing with a situation in which you have a will that leaves some or even all of the probate estate to someone that you're certain shouldn't inherit. Well, California has a law on what's called disqualified donees, which is a way of saying that California by law has decided there are entire classes of people that are prohibited from inheriting from a probate estate. In this video, I'm going to cover three things. The first is the classes of people that this law applies to. The second thing I'll explain are the exceptions to this law, and you need to know up front there are some very important exceptions here, and they may apply to your case. Third, I'll explain what happens if you can invoke the law and the law applies to your situation. California's law on disqualified donees is a complex technical law. In this video, I am not going to get into every nuance of the law because it would become overwhelming. What you are going to get in this video is a good overview that should give you an awfully good idea whether or not the law applies to your situation. If you think the law applies to your situation, it's important that you discuss this with a probate litigation attorney. The first category of prohibited transferee is the person who drafted the will. This applies both to lawyers and non-lawyers alike. If you have drafted the will, you fall into this category. The second category is the spouse or domestic partner of the will drafter, the relatives of the will drafter, and the employees of the person who drafted the will. The third category is a fiduciary who transcribes the will or causes the will to be transcribed. Now, transcribed is a legal term, but what it really means in this context is the creation of the will. So if the fiduciary does it on their own or has somebody else do it, that fiduciary is a prohibited transferee. Now, some common examples of this are either a conservator or a person acting under a durable power of attorney. Those people have a fiduciary relationship with the person that they serve. If somebody occupying that fiduciary relationship either drafts the will themselves or causes somebody else to draft it, they are considered a prohibited transferee. The fourth category of prohibited transferee are the spouse or domestic partner of the fiduciary that we just discussed a moment ago. Also in this category are the employees of the fiduciary and relatives of the fiduciary. The fifth category of prohibited transferee is the care custodian of a dependent adult. A care custodian is simply somebody who provides health or social services to another person. A dependent adult is defined under California law as a person who is 65 years of age or older and is unable to properly provide for their physical health, clothing, food, or shelter, or had difficulty managing their own financial resources or resisting fraud or undue influence due to a cognitive deficit. The sixth and final category are spouses and domestic partners of care custodians of dependent adults. Also in this category are the relatives of that care custodian and the employees of that care custodian. Let's turn to the exceptions to the rule. The first exception applies to relatives that are within 4 degrees of relationship of the testator. Now that sounds a little bit complicated, and it may be. If you're not sure if somebody is within 4 degrees of relationship, you need to actually sketch out the family tree and simply count how many degrees of separation there are within the family tree. Most often when we're dealing with family members, we're dealing with children, grandchildren. We may also be dealing with the siblings of the person who created the will. all of those people are within 4 degrees of relationship. All of those people are considered to be within the exception to the law. The second category of exceptions are people who are cohabitants with the testator. Now, cohabitant is very broadly defined. You don't have to be married, you don't have to be a registered domestic partner. Living under the same roof in many circumstances is enough to be considered a cohabitant. The third exception is where an independent attorney has provided a certificate of independent review. Now, there's a particular format for the certificate of independent review and it's entirely defined within the probate code. What this means is, if a person who has wanted to make a gift to somebody who falls within these prohibited categories goes to an attorney who did not draft their will, and that independent attorney meets with the testator and is able to truthfully say, this person is in fact making their own decisions, they're not being manipulated by the transferee, then that independent attorney is going to draft and sign the certificate of independent review. If all of those things have happened, then that is going to be an exception to the law on a disqualified donee. The fourth exception to the rule is where a will is approved after full disclosure of the relationships involved in a substituted judgment proceeding. A substituted judgment proceeding comes up in a conservatorship case. So for any of you who are watching this who had a loved one under a conservatorship where a will was created, this is important. A substituted judgment proceeding is where a person, usually the conservator, files a petition with the probate court asking the court to approve the creation of a will. What our law on disqualified donees says is that this is an acceptable way of creating a will, provided that all of the relationships between the people involved are disclosed, and of course, proper notice has been given to everybody who's entitled to notice. If the will is created this way, it is an exception to our law on disqualified donees. If you're not familiar with conservatorships, in California, a conservatorship is a court proceeding in the probate court where the allegation is made that a person is unable to make decisions for themselves. They may be unable to make healthcare decisions, they may be unable to make financial decisions. When a conservatorship is imposed on a person, it means that the court has rendered a judgment that this person, called the conservatee, is no longer able to make that type of decision for him or herself. The person who is in charge of the conservatee is called the conservator. The conservator has the legal authority to act on behalf of the conservatee. The fifth exception to California's law on disqualified donees are for gifts made in the will that are less than $5,000 in value. The sixth and final category of exceptions to the law on disqualified donees is proof by clear and convincing evidence disproving fraud or undue influence. Let me unpack that. This law that we've been talking about creates a presumption that this gift came about either because of fraud or undue influence. So what California's law says is that the person who's been accused of this wrongdoing has the ability to attempt to rebut that presumption. In order to rebut it, they are held to the highest standard of proof in civil court, which is called clear and convincing evidence, which means they have a very high bar they need to clear to show that, in fact, this was a proper gift, not a gift that was manipulated by the disqualified donee. If the law applies to your case, then the person who receives the gift under the will is presumed to have received that gift unlawfully. If they are unable to rebut this presumption that's created, the presumption of fraud or undue influence, then they are considered to have predeceased the testator. And what that means is the law deems them as having died before your loved one who created the will. And it's not just them. They are considered to be predeceased, so are any of their children, their grandchildren, anyone else in their line of succession, and their spouse as well. That's the law's way of making sure that both the person who did this as well as anybody who's related to them cannot inherit under these circumstances. The other thing that happens if you're able to successfully invoke the law is that you are then entitled to reasonable costs of litigation, including attorney's fees. That means that if you successfully invoke the law, the person who is the prohibited transferee is going to be on the hook for the costs of the litigation. You should now have a good idea of whether or not somebody is a prohibited transferee. In our next video, I'm going to discuss what some people consider to be the flip side to this, and that's where a person either isn't mentioned in a will or is unknown to a family where there is no will. What I'll be discussing in that video is called a petition to determine entitlement to inherit from an estate. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.